Hello, and thank you for joining us. I am Tammy Welty. I'm the Director of Training and Communications here at Bradford Barthel, and I'm here with Greg Fletcher. He's a partner out of our Sacramento office, and he is going to be leading today's discussion on how to prepare a compromise and release. This is a fantastic presentation, and I really hope you enjoy it. After you complete this entire webinar, workers' compensation claims adjusters are eligible for continuing education credit. Be sure to request your certificate by clicking the training certificate request link in the details at the bottom of this video under More. We offer monthly live webinars, which you can register for on our website at bradfordbarthel.com under the training tab. So again, if you go to bradfordbarthel.com, find the training section, you will also find our complete instructions for requesting your certificate on that training page if you are having trouble with the link in this YouTube video. The B&B blog releases an average of one article per week on current workers' compensation topics. You can find all of our blog articles on our website, again, at bradfordbarthel.com. Do you have a complex medical report to rate? Consider sending it over to our AMA analysis and rating department for a review and thorough analysis of your report. And that's all from me. Greg, you want to tell us a little bit about yourself before you get started?
Yes, hello. My name is Greg Fletcher, and I'm at the Sacramento office of Bradford Barthel. And at the end of April, I'll have been here 25 years. Well, not here at this office, but working for Bradford Barthel. I also worked in-house for a large insurance company before this, and so I've had experience working for in-house or as in-house counsel, and also outside with Bradford Barthel, working for different clients. So, all right, today's topic is how to prepare a compromise and release. I think it'll be instructive. We'll start with a little bit of theory, and then we'll get into the actual nuts and bolts of how to prepare the settlement documents themselves. This is my contact information. You can get this PowerPoint online. There's a link to it, I believe. And so you can always find me if you need to ask a question or you want some follow-up or something. There's my contact information for you. All right. When do you settle by compromise and release? When you're off the risk, when you want to settle future medical care, and also when the claim or right to benefits is disputed. You can settle by compromising, and you don't necessarily have to try that issue. So advantages of a compromise and release: it resolves all issues, or it resolves the issues you want to resolve. Hopefully we're trying to resolve them all. There is no right to reopen, unlike the stipulations, which can be reopened within 5 years from the date of injury. Once you do the CNR, you're done. All the issues you've resolved are resolved permanently, hopefully. And issues such as penalties could be resolved without any admission of fault or liability. So that's quite attractive to a lot of us and our clients as well. When do you not settle by compromise and release? When you're still on the risk, because your compromise and release may duplicate settlement of future claims. That is particularly true when it comes to future medical care. If you settle future medical care and the injured worker is still working for you, when the ink dries and they get their money, they can bring another claim, and if that's for the same body parts, because medical care is not apportionable, you're stuck with paying for the entire medical bill for the subsequent injury, even though it may overlap to some degree the treatment that you already settled in your CNR. So that's the main reason why, if you're still on the risk, and primarily that means the injured worker is still working for your insured and you still have an insurance policy in place, that you don't want to settle future medical care under those circumstances. Often a party will be unwilling to settle medical care. We used to back out a lot back in the days when the MSAs would come in exorbitantly high. We would not want to fund them, and we'd say, we'll take our chances. We'll leave medical open, and we'll just see how it goes, because we don't want to pay hundreds of thousands of dollars. The dust has settled. We're getting recently very reasonable MSAs, so that's less our concern. But often the injured worker doesn't want to settle future medical care as well, and there are good reasons why they might not want to do that, even though it kind of frustrates our hope to resolve the claim with finality and get them off our books. But both parties have to agree in order to settle future medical care, and that's true of compromise and release in general. Sometimes a party will object to your settlement. The time that I've seen it is with death without dependents unit. This gets into a little bit of how the death claims work, but most of you know this. If you don't have a dependent, the state gets their money. They get the full death benefits, and it's paid to the state. So sometimes you find a dependent, and if the state gets wind of it and decides that that's not in good faith, if they really weren't dependents, I have had the death without dependents unit object to my CNR on the grounds that we've cobbled up a dependent and we're trying to avoid paying them, which was true, but we believed that we had actual dependency, at least partially. Other times there may be a co-defendant or somebody whose rights are involved or interested who might object to your CNR. It's extremely rare, and you almost never see it. And most of the time, somebody whose rights are affected but is not a party to the CNR doesn't know you're doing it until afterwards, and they may not even get served if they're not a party. So this is a rare circumstance. Usually it's between you and the parties. So what benefits can you settle by compromise and release? Temporary total disability, temporary partial disability, permanent disability, life pension, future medical treatment, out-of-pocket medical expenses, penalties, interest on delayed payments. Under some circumstances, vocational rehabilitation. We don't have cases that are that old anymore where we have VR, but we also have the voucher, the supplemental job displacement. And under certain circumstances, prior to 1113, you could settle it, and under certain circumstances, you still can. What can't be settled by a CNR, first, claims over which the WCAB has no jurisdiction. That should be a no-brainer, but people try and get away with all sorts of things. Civil claims, FEHA claims, ADA claims, retirement issues. You can do a third-party CNR. Technically, that's only settling the workers' comp portion of that settlement, even though it's approved at the board and you're reciting the civil settlement. The civil settlement is really separate, and you're just informing the board that there's a civil settlement, and therefore your CNR is adequate because the applicant got most of their money or a good portion of it in the third-party settlement. Unknown claims cannot be settled. That should be obvious too, but we have lots of boilerplate addenda that settle claims known or unknown. The board will strike that language. You can't settle the voucher without certain circumstances for claims after 1113. In the old days, we could settle voc rehab based on the case of Thomas versus Sports Chalet. You've heard the term Thomas finding. That's where that comes from. If you have a good faith issue that can defeat applicant's entire claim, then under the pre-existing law, when we had voc rehab, you could settle vocational rehabilitation, even though statutorily that was prohibited. When they brought the voucher in, they basically imported the same language. The settlement of the voucher for injuries on or after January 1st, 2013 is prohibited by statute, but we do have a workaround, which we'll get to in a minute. Is there a Thomas for the voucher in a 1113 and later case? Well, yes, there is, and it's the Beltran case, and it basically runs along the same lines. If you have a good faith issue that would defeat applicant's claim, then in connection with your settlement of the other issues, you can settle the voucher as well. What's interesting is since the voucher really represents less of an expense, less of a benefit to the applicant, they're less stringent on the language. We don't have the so-called Thomas finding that we used to have. We simply say we're settling it per Beltran, and generally that's good enough. Under Thomas, you had to make an offer of proof. What is the issue? What are the witnesses going to say? What do the records say? Whatever is the basis for your good faith issue needed to be presented to the board. There are still good reasons to do that, and we'll get to that later. When should you first think about settlement? Well, you should always be thinking about settlement, so that's a trick question. Do you wait till the injured worker is permanent and stationary or at maximum medical improvement status? Do you wait till they're MMI for all body parts? Not necessarily. Do you try and settle for nuisance value when the claim is denied? We consider settlement at every stage in claims handling. If you don't, you may miss opportunities. And the way I think of it is there's a running total as the claim evolves. I get a file, I review all the documents. With a lot of experience, you can usually get a sense of where the value is going to be if it's the kind of injury that you've seen many times. If it's a torn meniscus in the knee, if it's a shoulder that needs arthroscopic surgery, if it's a back that's been pulled in a lifting incident and there's a herniation on the MRI, we can all kind of see where those are going and get an idea what the value is. So as I continue to handle the claim, there's a running total. What can I settle this case for today? Often that total is higher than I want to recommend to the client. I could get it settled, but I don't want to pay that amount. So I'm saying in my correspondence, the claim is worth this. I don't recommend that we offer that. Let's keep with our discovery. Let's try and get the person at MMI. Whatever it is that's going to help us with some cost savings, we move forward. When those two lines come together, what you can get it settled for and what you're willing to recommend, that's when you jump, and hopefully the other side is in agreement and you can settle the case. Hurdles to settlement: the injured worker or the applicant's attorney, sometimes they're very difficult. Sometimes it's hard to understand what they think is important about the claim. What do they want? So we're missing the mark when we're making offers. The WCAB, the judge, the INA officer, these are all parties involved that we might have to negotiate with or deal with to some degree in order to get our settlement negotiated and then approved. This is my little rule of thumb. It's Fletcher's rule. A compromise and release is less about the numbers and more about who wants it more. That is as true today as it was when I came up with it. Really, again, to find out what the other side wants. What are they interested in? Are they interested in their medical treatment? Well, then it might be hard to CNR the case. Are they just interested in money? Well, then let's get something that's attractive to them, but something we can live with. So the real motivator is what's going to drive the cost. If applicant's counsel is desperate or applicant is desperate and really needs the money, they often will settle over the advice of their attorney, even if they're desperate. And maybe we understand that, and that's part of our dynamic in negotiating. If we really want to get rid of this person and the employer maybe wants to get rid of them, we have motivation to then come up, maybe offer a little more because we have certain concerns that we're looking for. All right, neither side can be forced to settle by CNR. It's always by agreement of the parties. Valuing a case is obviously outside of the scope of this seminar, but the question is the settlement that's being proposed cost effective in light of the risks? It's all about risk management. So you identify areas of agreement and areas of dispute. You weigh the arguments of each party in the areas of dispute to see, what's the appropriate compromise. One way to look at this is, what's the percentage of likelihood I'm going to prevail on this issue? If it's 10%, maybe that's how I value it. I value it more on the other side. If I'm confident and I think got a very good chance of prevailing, then there's no reason to give more money away. I'm going to prevail at trial. Maybe I should just take it to trial. So these are the thoughts that go into putting your settlement together. Now, a settlement has to be approved by the Workers' Compensation Administrative Law Judge. That is Labor Code Section 5001 and Board Rule 10882. That directs the appeals board to inquire into adequacy. That is very different than civil practice. In civil practice, you can settle for $1 and you just tell the judge, we've settled. They don't even have to know what the amount is. You file a petition to dismiss based on the fact that you've settled. Nobody looks at it. They just dismiss. You both agree? Doesn't matter to us. In workers' compensation, the board and the judge has to look at the settlement and decide that it's adequate. So that creates an extra layer for us to persuade the board that we are, in fact, providing an adequate settlement. Does that mean the injured worker gets everything possible on the record? No. The settlement has to only be within the range of potential outcomes, but it should be significantly within the range. If it's on the very bottom end, then the judge is going to lean on you. But if you have a 0 on one side and 100% on the other side, and there's some facts that support one and facts that support the other, in theory, anything in between would be reasonable because it would be in the range of potential outcomes. The way the board rule is worded is that agreements that provide for payment of less than the full amount of compensation will be approved only where it appears that a reasonable doubt exists as to the right of the parties, or that approval is in the best interest of the parties. That's another thing that a lot of people miss. Sometimes settlement is in the best interest of the applicant, and for example, you might have a very elderly applicant, but in a stip to a high amount, but they're never going to see that money. So you might compromise and release under the full value of the stip, but it might be in the best interest of the injured worker because they're going to get actually a lot more than their life expectancy would suggest. So there are a lot of factors to consider. Now, what does the judge do when they're trying to decide if your settlement is adequate or not? Well, they have certain tools. They will go to the DEU and get the reports or report rated. They will sometimes run things by the information and assistance officer, particularly if you have an unrepresented injured worker. It's always helpful to suggest to them that they speak to the information and assistance officer. And if you can tell the judge they talk to the INA officer, then that goes a long way to help the judge understand that you're not trying to fool anybody, you're not trying to trick anyone, that everything's above board and in good faith. And in fact, you're encouraging them to go to the information and assistance officer and go over the settlement if they have any questions or they have any concerns. What do we have? What does the claims examiner have in terms of tools to establish the adequacy of the settlement? Well, obviously, there's superior skill in drafting the CNR, which you will have at the end of this seminar, and obviously supporting documents. You provide everything to the board that they need in order to understand your settlement and to determine that it's adequate. I can't emphasize this enough. Explain, explain, explain. What you're trying to do, and this is always the case, is make the judge's job as easy as possible. Just hand it to them, lay it all out. It's nothing. Most of your settlements are not particularly complicated. Obviously, some are, but if it's straightforward, just say this is straightforward. This is a knee. There was surgery. The report rates to this. The future medical is that, and that's why we're settling. When you submit the settlement, the judge has certain options. The judge can approve it, suspend the settlement and make inquiries as to the basis or missing documents, set a hearing on adequacy, or even disapprove the settlement. Now, what the judge cannot do is make unilateral changes to settlement documents, and there's some sites there. What I'm hearing from our Southern California attorneys is that judges down there will lean on the parties to make changes in their settlement documents that the judge wants, and the threat is that they will immediately go to trial if you don't go along with their proposal. I don't think that's exactly what the cases prohibit here, but it certainly smells a lot like it. And I would say that if you have a case down there, just be ready to call the judge's bluff and go to trial if they're trying to introduce language in your compromise and release that you just can't live with. There is a provision where if something is submitted and the documents fall through for whatever reason, the settlement is not approved, that you can have an immediate trial. So it's not completely out of the realm of possibility. It's not completely running afoul of what the regs and the system provide. The form, now we're getting into the actual compromise and release form. The form is actually in the form of regulations. The labor code says what should be in the form, and the form is then generated and it becomes one of the regulations, and that's how it becomes official and part of our process and our system. There are other compromise and release forms that we're not discussing today. You can get a hold of me independently if you have one of those and you're trying to work through it. There is a separate death and dependency claim form. That's for very good reason. The injured worker in a death claim is deceased. You don't have an injured worker. What you have are dependents, and there may be quite a few of them. So there's a separate form in which the dependents are listed and the issues are set forth that align better with a death claim as opposed to a claim for injury where the injured worker is around and can settle with you. The other form that we're not using is the third-party compromise and release, and we touched on that a little bit before. If an injured worker has a third-party claim that arises out of the same incident or accident that is the basis of your workers' compensation claim, then you can have a right to a third-party credit, and they might have a third-party recovery. Those things can be settled in coordination, and when you do that, you can submit to the board a third-party compromise and release that says this injured worker got X in the civil settlement, and we're paying Y to bring up the difference in the comp claim, but we recognize that we have a credit and so forth. So that's a separate document, and it really is outside of the scope of this seminar. It's not normal, and you really need the workers' comp claim and the civil claim to settle together for that document to be relevant. Often they are on completely different tracks, and so you're not going to do a third-party CNR. The civil settlement is long before you settle your comp claim, and you simply file a petition for third-party credit, or your comp claim settles, and then they buy out the lien. Hopefully you file the lien or you've intervened in the civil claim. All right, moving on. This is the form itself on page 1. Well, we'll get to the form, but this is instructions. Include all the case numbers. If you don't include a case number, you didn't settle that case. Include applicant social security number. Although these days, I think we're leaving it off for privacy reasons. That creates some additional issues, but I think that's custom and practice now. The venue, there's a place where you identify the basis for the venue. I usually go back to the application and look at which box the applicant's attorney checked. Typically, I would let applicant's attorney fill in the address. Some of our injured workers move around quite a bit. It becomes a problem when the check for the compromise and release is sent to the wrong address, and then they want to say that's your fault, and that's an unreasonable delay, giving rise to Labor Code Section 5814 penalties. If you let the applicant or the applicant's attorney fill in the address and you send the check to that address, they don't have much of an argument that you send it to the wrong place, even if they haven't updated the WCAB official address record. And if they give you a new address, I would urge them to do that because you never know. Hopefully you're done with your CNR once it's approved, but if there are other issues, you want to be sure the board and the notices go to the right address. Provide the employer name and address with accurate information. There was case law. It's now a reg. If you mistakenly identify your employer, you can be sanctioned. And in particular, if you identify them as self-insured and they're not. That is the Cold Iron case from 2002, now codified as reg number 10390A. And in that case, I digress a little bit, but the sanctioned party in that case was actually representing a carrier that had gone into liquidation, and so their client was SIGA. And those of you who've dealt with SIGA know that they often get out of claims. They do not pay out benefits in cases in which there is a viable carrier. They only pay for covered claims, and that's by statute. And so once you know someone is SIGA, you recognize that they may get out of the litigation, particularly in cumulative trauma cases, and it very much affects the rights of the other parties. So in that Cold Iron case, there was reason to sanction those folks because they, at the last minute, let everyone know they were SIGA and that they got out, and it changed everyone else's liability and prejudiced them. So there's good reason for the case. I'm not so sure that reason applies in every case in which you might make a mistake about whether you have a self-insured or whether you have a insurance carrier, or whether you're listing a TPA instead of a carrier. That's a common mistake that judges pick up on, and it's definitely something to avoid. All right, so here's the form itself. Here's the case places where you put the case number, social security number here. These are the boxes we're talking about regarding venue. Again, leave the applicant's address blank. Be accurate regarding the employer information. The second page of the form has a space for applicants and defense attorneys. If you don't have attorneys, those of you who are claims examiners and are filling these things out, just leave that blank. There's a difference between the insurance company and the claims administrator. The administrator is the TPA. If there is no separate TPA, you can just list the insurance company. And here's the spaces for applicant's attorney and defense attorney. And then this is insurance carrier. So we distinguish that from the TPA. It's on the page after that. So, and once again, I'm telling you here to distinguish between the TPA and the insurance company. Interestingly, I often don't know the address of the carrier. I'm dealing with the TPA. That's who sent me the file. And I have traditionally put the same address and have never had a problem with this up until I drafted this CNR seminar. And then I had an applicant's attorney call me out on it, and he had Googled the insurance company, and he insisted that I correct it, along with a dozen other nitpicky things that he had issues with in my CNR. But it kind of threw me. I was surprised. Typically, I don't have a problem putting the TPA's address as the carrier's address. Uh, the board just wants someone on the hook if there's a problem, if things don't get paid. Best practice would be to put both. I, as the attorney, don't always have that. The claims examiner should have that information. So also check and make sure all your information regarding the claim is correct and consistent with what is in EAMS. The way EAMS works, if there are inconsistencies that can hold up processing of your CNR, this is something I rely on my staff for, but it has been brought to my attention and our attention that sometimes the attorneys are filling out the documents and EAMS information is different. Sometimes you have to go back to applicant's counsel and have them correct what they've got in EAMS, what they've alleged in their application, if you need to clean that up and make sure it's consistent with your settlement. There is a space for occupation. You may not agree on what it is. It is reasonable and acceptable to put in dispute, but I would do that if there actually is a dispute, because there are judges who will take that language and play a little game of gotcha, really, because we used to put in dispute on almost anything we didn't want to spell out. But judges started getting in the habit of inquiring. You say in dispute. What is the dispute? What's the basis for your compromise of that dispute? This is actually not inappropriate, because if you think about it, if there is a dispute, that means that you don't agree. And that means that one party is arguing, usually defendant, that applicant's going to get less as a result of this issue, and applicants arguing they should get more. How does the judge know the settlement's adequate if they don't know how this dispute was resolved? So I tend to not identify disputes that don't exist, and the ones that do exist, explain the basis of how you compromise it. Again, let's go back to that basic principle. Explain so much that the judge doesn't have any questions. Make their job easy. We are trying to assert that compromise and release settlements are awards of permanent disability. If we could establish that by case law, we could get apportionment under Labor Code Section 4664. So if you put information in your compromise and release that identifies exactly the specific PD rating, most of us put the rating string in the CNR. It doesn't get more specific than that. But whatever you do to make it specific, you may ultimately have a payoff in the future, or someone may, if it is decided that your compromise and release is an award of permanent disability. And we'll touch on that in a minute. So this is claims administrator, and I put TPA here. So that's different than the previous page, insurance carrier. If you don't have a separate TPA, you don't need to fill anything out here. And then now this part is where you're into information about the injured worker and the injuries. Date of birth is here. Again, occupation, we can write in dispute. Typically, we have an occupation we agree on, so we just put that number in, or we write the name of the occupation. Sometimes you've actually resolved a dispute and you've agreed on an occupation. You can put that right in there, or in a comment or an addenda where you're explaining the basis for your settlement. Now, I've done two examples. I started with a specific injury. If you have a specific injury, you use the start date as the date of injury. You notice it says end date. Well, you don't have an end date. You just have the specific injury date. But put that on the start date. The ADJ number. Sometimes you don't have an ADJ when you submit your CNR. That becomes what they call a case initiating document. And there's a process for obtaining the ADJ number that you need. And that's part of what happens at the board. And so don't worry about that. When you submit it, just be aware that they will generate an ADJ number when they're processing your CNR. You list all the body parts with the numbers, codes that EAMS provides, and you need to provide where the injury occurred. The main thing you need is to provide jurisdiction. Be sure you identify somewhere that it occurred in California. If it didn't occur in California, you may want to have some information that establishes jurisdiction. It's usually not questioned by the time you're settling your case, but that's the reason why we need to know where the injury occurred. Most of the time, it's establishing jurisdiction. So this is an example of a CT. You have the AGJ number. You check the box indicating it's a cumulative trauma injury. And now you have two dates, the start date and the end date. You still list all the body parts and the injury occurred, where the injury occurred. Typically, I will draw a line through the injury entry sections of the compromise and release that I don't use. That way nobody can write something in later. Applicants and applicants' attorneys tend to appreciate that. Here is an example of the body codes list. It's pretty extensive. It doesn't cover everything. You do have unclassified at the end or other body systems. And so you could put that in and then specify in the comments if it's some body part or system that doesn't quite fit this scheme. So claims information applies to all claims with ADJ numbers. Specific injury, use the start date. Cumulative trauma, start and end dates. Now, we all know, or most of us know, that cumulative trauma injuries are decided in terms of liability based on the last year of injurious exposure. It's the statute actually says last year of work in the industry or the year preceding the date of injury. And that's a whole issue involving the Western Growers case and so forth as to when your compromise and release is. Typically, what I do on the settlement is I just list the dates that are on the application. Some applicants' attorneys will plead a CNR, plead a CT, I'm sorry, cumulative trauma, as 1 year, sort of applying Labor Code Section 5500.5 out of the gate. I personally don't think that's entirely correct. I think the best way to do it is to figure out medically, how long did this person work? Did they work 20 years in the industry? Did they work 6 months in the industry? Whatever that is, that's what I would put in my pleading and let the application of the statute that limits liability play out as the case evolves. Again, it may be the last day they worked. It may be earlier based on their date of knowledge. That's that Western Growers case. The date of injury for a CNR is based on knowledge and disability. So you could be working quite a while after you have that actual date of injury once you know you have a CT. So again, the easiest way to think of it is just look at the application and list whatever's on there. And that usually is correct. And this is basically just saying what I just said. If only the end date's alleged, you might just pick a year if you know the person worked for that full year. If the end date is alleged and they somehow didn't provide you with a start date, then I would, and if based on their actual dates of employment, it's less than a year, then I would start with the date they started working if you have that information. All right, continuing on the form, when you are listing the body parts that you're settling, definitely use the EAMS codes if you have them. If you don't list a body part, there's an argument that can be made that you didn't settle the injury that caused impairment to that particular body part. So it is very important on the CNR that you be as comprehensive as you can. You want to cast a wide net, allege every body part that could possibly have been injured by this injury so that you're settling them all. EAMS doesn't specify between right or left when it comes to upper or lower extremities, so you may want to clarify that in the comment section. You definitely don't want to settle something that wasn't injured. Well, that doesn't matter as much, but you don't want to leave something out that was injured and have them come back and say, oh, you settled my left arm, my right arm is hurting, and we didn't settle that, so you owe me more money. The electronic form, and this is something you're going to have a problem with a lot of times. Back in the old days, those of us who've been around a while, remember we used to fill these things out primarily at the board by hand, and it didn't matter how many characters you used because you could write in the margins. As long as it was legible, you could pretty much modify it to fit your case or your settlement. With EAMS, you have a certain amount of characters that are allowed in the form, and so you have to get creative. I do have some workarounds on certain spaces, which I'll share with you. But do your best. If you can't get it, what you're trying to do in the space provided, that's what the comment section or an addenda is for. So there's a section where you recite what payments were made, be accurate, provide the average weekly wage for earnings. Once again, if you write in dispute, a judge may say, what is your dispute? What average weekly wage did the applicant claim that he or she made? What average weekly wage is the employer or the defendant claiming? And how did you compromise that? And if you didn't, you could be a little embarrassed when you just say, well, we just didn't know what it was. How do we know that the settlement is adequate if we don't know what the earnings were? The earnings are how we decide what the rates are, and then we pay for a certain number of weeks. Judge needs to know what the law and the facts, the records, typically the medical reports, would generate in terms of liability, so they know when you settle that you're in that range. All payments of TD, PD, and medical expenses are provided. The most important, you'll list the periods, of course, in the comment section if you need to. Sometimes you've paid multiple periods of TD, for example, and there's one space on the CNR start and stop date for TD. What do you do if you paid 5 different periods? Well, there's different ways of handling it. You could list all the periods in the comment section. You could provide the very first date and the very last date, and then provide language that it was paid in broken periods. You could provide the first period in the CNR form and then the additional periods in the comment section. None of these are wrong as long as they're accurate and they're clear and they're understood by the judge. For example, TD paid January 1st, 2012 through April 1st, 2012 at the rate of $400 per week. January 1st, 2013 through June 1st, 2013 at the rate of $400 per week. That is perfectly clear. TD paid in broken periods, as long as you provide the total and the start and the stop date. That's also not inaccurate. Sometimes you pay a lump sum because you're paying some retro. You can put that in the comment section as well. Wage loss is tricky because that could be if somebody is losing hours and it's a different amount of hours each week, their wage loss payments are going to vary week to week. So the judge doesn't necessarily need to know what you paid every week. You provide a total and you say it was paid as wage loss at varying rates from this date to this date. If they have questions, they'll ask. Don't panic if a judge asks a question. Just answer it as promptly as you can. Medical payments, you provide a total. Technically, you don't provide medical legal costs or medical management. Nobody ever questions that number for the most part. I have had one instance where somebody, when they were trying to file a serious and willful petition, which gives an increase of 50% of the benefits, they tried to argue, oh, you put it in your CNR, so you made a representation that that was paid in medical, so we get 50% of your med legal and so forth. So there is a reason to keep that number as accurate as you can make it. Here's the form itself. This is the last case. Again, if you're not using that, I'd put a line through it. Sorry, jumped a slide. Here's the place for average weekly earnings. Again, I would put a number in there if it's in dispute and you've resolved the dispute. You could put that in the comment section, or you just put the resolution of the dispute. If you agreed on a compromise average weekly wage, just put that in there. You don't necessarily have to put in how you arrived at every figure here. This is for TD. You put a total here, the weekly rate that you paid, start and the stop date. We've already dealt with how you handle this if you didn't pay in one period. And there is a comment section and you can add some explanations there. This is permanent disability. You provide the total, the rate, the start and the stop date. Here's where you put your total medical treatment, and then unpaid medical expenses. I typically write this per P8, meaning per paragraph 8. That paragraph has to do with liens. I have had one judge call me out and say, that's not unpaid medical expenses, that's liens. How are you going to deal with the expenses? I have other language that I use, and what I write is DEF, and then THRU, and then OACR. That's the one thing you might want to write down because that's not in the PowerPoint here. But what that says, if you read it to yourself, is defendant through order approving CNR. Again, DEF, THRU, and then OACR. And that is read as defendant through order approving CNR, which is perfectly understandable and makes sense. You're going to pay the medical bills that are outstanding until the CNR is approved. And the nice thing about that language is it does fit, the characters fit in the form. So unpaid medical expenses, if the claim is denied, I mean, you can, if you want to get away with this, you can write applicant in that space, and we've done it and judges have approved it. However, I have had some judges in accepted claims look a little sideways at basically putting in the CNR that applicant's going to pay unpaid bills themselves when we don't know what they are. But our response is we don't know what they are either. We don't know what applicant is, how they've treated. And one response to a judge saying, well, you're throwing this to the lien section, that language that I put in there per paragraph 8 is if they want their bills paid, they can file a lien. And so we're going to handle it that way. I haven't actually used that argument with a judge yet, but we'll see. It might work. They may want me to modify it. Again, this is because EAMS only allows so many characters, so you've got to be creative. Again, unless you want to put it in an addendum somewhere. An explanation could be included on page 6, paragraph 8, which is a big space that allows for addressing liens, and we'll get to that in a moment. Note resolution of all liens, and that would be on page 6, paragraph 8. Typically, you want to get EDD to sign off on your CNR. Other lien claimants, I just settle outside the CNR and note the lien resolutions when you submit it. If your case is venued down in Southern California, there's a whole lien affidavit that they have people include. It's not really part of the regs. It's not something we do up here in the north, but they want to know that all the liens are resolved. They have typically more liens than we have, and a good part of the litigation involves liens down there, and so it's very helpful. I had an addendum that listed all the liens that were resolved when I came up here, and that was many years ago. Now it's really more official. Yeah, you could do a lien in a separate stipulation and order. If you trust the lien claimant, you can settle informally. What you do want is something in the board file that shows the liens resolved. So if you settle informally, I would hound them to withdraw their lien. And this is why settling by stipulation and order that's approved by the judges is helpful, because once that approval is issued and the stip and order approved by the judge goes into the board file, it's in there. The resolution of the lien is then official, and anybody looking at the board file can see that you resolved it. What you don't want is some new lien rep to come out of the woodwork and talk to the lien claimants and say, oh, you may not have settled these liens. Let's go back. We'll relitigate them. You never know what these folks do, and sometimes it's long after the fact. Fortunately, we have good statutes of limitations on liens now, so that prevents some of that practice. All right, this is where you're actually talking about what you're settling for, the amount of the settlement. You put your gross amount here. This is everything that's being deducted, PDAs, and through a certain date, typically the date of the printout. Explain what if you have a temporary disability overpayment, that just because you recite it here doesn't mean it's automatic. Anything coming out of the CNR is listed here. Child support liens typically come out. Lien for living expenses. You don't see this that much these days, but in the old days, folks would go to their landlord and say, I have a comp claim. Can you file a lien and you get your rent paid when I settle my case? Some landlords would work with injured workers and do that, and then file a lien for living expenses. We don't pay that in addition to the CNR. That comes out of the CNR. Sometimes you go after EDD for a part of the CNR. Part of their lien, and that comes out of the CNR. Typically, we're paying that outside. There's a question, do you include the MSA? I think best practice is to do so. If it's a small amount, if it's under the review threshold, if it's self-administered, there may be less reasons to include it separately here. But it does explain what you're doing and what part of the settlement is going toward the MSA, so I think it's helpful. If there's an attorney, have them leave the attorney fee blank. Then the net to the applicant is here. There's an issue. That net is only accurate through the date of your printout if you're paying ongoing PDAs. But notice that it says, and less further permanent disability advances made after the date set forth above. That protects you, and that's very helpful. The key is to make sure that's also reflected in the order. There are some orders approving that don't include permanent disability advances made after the date that's set forth in the CNR. That's risky. And you have to ask yourself, do you want to go back to the judge and say, issue a better order? So typically, we're submitting orders and we make sure that that's in there. This is an example of how you would have an EDD resolution right in your CNR. You have them agree to accept a certain amount and the amount of the lien, and then typically the period that they paid. So that protects EDD. If they paid some other period that didn't get settled, they can come back for that. So you want to make sure you know everything they paid. You can recite liens that have been resolved. Typically, you add pay, adjust, or litigate language for all unpaid bills and liens. I would not hold applicant harmless with respect to medical liens. You lose certain defenses if you do that. It's kind of technical, but the main defense you lose is that they treat it outside the MPN, and that's a good one. So I will hold applicant harmless with respect to EDD if I'm positive that we're not going to deduct any of the EDD lien from the settlement if it's all going to come out of what we would have paid in TD. But I'm more reluctant to hold applicant harmless on medical liens because you do lose certain defenses. All right, again, this is just what we talked about. You might want to deduct some of the EDD lien from the settlement. Sometimes we work out a deal. If applicant got duplicate payments, for example, we pay some and we get them to pay some. So that you've got to recognize that that would be deducted on that line where it's allowed. Medical treatment, again, don't hold applicant harmless. Here's the case that talks about how you lose certain defenses if you hold applicant harmless. It's instructive. All right, you start with a gross amount, you work through the deductions. The PDAs, I can't emphasize this enough, be accurate with the PDAs. I can't tell you, that's one of the most common mistakes that you see, particularly with defense attorneys. They misread the printout, they get the PDAs wrong. Sometimes they have someone who is generous and sympathetic and they can correct that. Sometimes they don't. Sometimes it was negotiated based on that representation. This is what we're deducting. And you wouldn't have gotten your settlement without reducing those PDAs. But that's a big hit. If you paid out in permanent disability, you don't get your credit for it. So if it's not in the form, you didn't settle it. Be sure that you're accurate with your PDAs. We talked about this. The form gives credit for PD paid after the date on the printout or the date listed on the form. Just be sure that that's taken into account on the order. Again, you're probably going to lose credit for it if it's not included as a credit for PDAs, and that's County of San Joaquin versus WCAB, 2011. Can you write subject to proof? Will that protect you? Notice I didn't answer that question. Don't be in a position to do that. Try and be accurate. Now, moving on to TD overpayments. Just because you list it doesn't mean you get it. It's discretionary. There is a J.C. Penny case that talked about an AME, I think in that case, retroactively P&S the person. So in other words, they'd been paying TD for 6 months, a year, and suddenly that's an overpayment because the AME says, oh no, they were P&S a year ago. In that case, which was Judge Samuel in Sacramento, who in my opinion decided this wrong, but the Court of Appeals agreed with him. He said you should have objected under Labor Code Section 4062, and since you didn't, you don't get credit for that whole retro period of TD. So it's a terrible case, in my opinion, bad law, but it is the law. Here's why it's bad law. It creates an incentive to object immediately when the treater finds someone TD and go to an AME or a QME way before the person's MMI just to preserve that objection. It just seems like a real waste, as opposed to being able to say, look, our AME said this person didn't need the TD we paid. Give us a credit for it. I think that's much more reasonable. But be aware that case is out there. And so if you're claiming a TD overpayment, spell it out, explain what it is. The most common one is just the gap between getting the QME report, the time it was issued and the time you get it in the mail, and then you can get to your system and stop the payments. Most judges will allow that credit, but there are a few who won't, and I don't really understand why, but I don't see where you had any fault there. You acted diligently. There's a gap of a few weeks of TD. It really isn't a whole lot. Most judges should allow that. All right. Other deductions, we talked about these liens for living expenses and so forth. Make sure you provide documentation so the judge knows it's really resolved. That's pretty important. If settlement of the EDD lien includes payment by applicant, deduct it from in that list of deductions. Leave the attorney fee blank, let them fill it out, but check the arithmetic. I can't tell you how many times I failed to check the arithmetic and had to go back and get something corrected. Applicants' attorneys are as bad as defense attorneys at arithmetic and math. So when they deduct their attorney fee, double check the total to the applicant and the arithmetic there. Do you include your deduction for the MSA? We talked about this. I think it's best practice to do so, but there are times when it's a small MSA, you're under the review threshold, and you could simply put in the comment section that you have an MSA. Now, this is very important. Every issue you settle, both parties need to initial. And this is a little misleading in a way. These initials are typed in here. We had one judge in what is now the Lodi board criticize us for not having wet signatures, wet initials. In this day and age, I just can't imagine why that would matter. And that was on the part of the defendant, not even the applicant. So it is best practice to actually initial these things. I've seen a lot of them typed, and I don't really, this is the only time I've ever heard of a problem, but it's a nitpicky thing to hold up your CNR. So initial these. You'll notice there are a number of boxes. I haven't initialed every one. And then there is a comment section, which is woefully small. This is the most basic comment you could provide in your most basic settlement. Just simply say it's based on a panel QME report of Dr. Fibes. If those of you who know Vincent Price know that reference, rated by the DEU at a certain rate. I mean, if you have a DEU rating, that's gold. Tell the judge we agree with the DEU. That makes the judge's life so much easier, and they don't question your rating. But again, check the boxes that of every issue you're settling. If you don't check it, you didn't settle it. And once again, and there's a case. This case is just awful. This is a writ denied case. The CNR had an addendum indicating that they were settling the Labor Code Section 132A petition, but the box discrimination, and I'll show it to you, discrimination was not checked. So the court said, you didn't settle the 132A. Imagine how the employer felt about that. So really be careful. Now, the next question is, do you initial every box? I've seen it done quite a bit, but it raises that same issue that we talked about, which is there really a dispute? If you initial a box that you're settling as an issue you're resolving, then the judge may say, what was that dispute? So I only initial the boxes that relate to issues we're actually settling. That I think is best practice. But it is a little tricky because once again, if you leave it out, you didn't settle it. So if you check every one, you obviously didn't leave anything out. But if you check 132A and serious and willful and there aren't one, that's just sloppy, and that's going to create some questions on the part of the judge. What did you pay for that? And that's going to be embarrassing. So again, best practice, initial the issues actually being resolved, and also make sure to have applicant or applicant's attorney initial those issues as well. The comment section, and this is important, this is your basis, your opportunity to explain the basis of your settlement. Anything that you think is a little hinky, to use a technical term, that you think the judge might have a question about, put it in the comment section. There's a common myth, I think, that they hate addenda, that the judges hate any addenda, and that you should really work very hard to avoid any addenda in your CNR. That is absolutely false. If the comments that you need to put in your CNR to explain the basis for it, to show the judge that it's adequate, spill over that tiny box that's provided in the form, and you need to put it on an addendum, just do it. And what you need to write then is, Addendum A is incorporated into this settlement, somewhere in the comment section. And then Addendum A explains what you need to explain. The key is keep it simple. Don't have pages of boilerplate. Don't have lots of overreaching language, settling the known or unknown, settling the civil claims, holding the defendants harmless if CMS comes back and says the MSA is inadequate. There's all kinds of language that are just red flags the judge is going to strike. And that's going to flip the presumption against you. If you're spelling everything out and it looks like it's all tracking, then you have a presumption in your favor. Oh, this person knows what they're doing. This settlement is going to be adequate. When you start doing things that make it look like you're trying to get away with something, then the judge is going to scrutinize everything in your settlement. The key is, why is it adequate? And you provide your basis of PD. Remember we talked about giving the rating string? We were trying to establish that CNRs can be awards of PD. We're not quite there yet. Provide a dollar value if you provide the rating. Again, make it easy for the judge to look, okay, PDs were 20,000, they're settling for 50. What's the 30 for? Oh, 10 is for retro TD, 20 is for medical. Looks adequate to me. Sign off on the order. So will percentage of PD be sufficient for Labor Code Section 4664? There's a case out there, it's an old case, Pasquoto, shortly after things changed and we got the new apportionment statutes, Labor Code Section 4664 provided that an award of permanent disability would be conclusively presumed to still be in effect. The basis for this was, the reason for this was we had lots of cases where somebody would step out to 50% disability and 5 years later they have the same injury and the same body part. And when you hold that step up in your deposition and you say, didn't you step out to the 50%? And they say, well, but I got better. And then I had your injury. Well, they don't get to say that anymore as long as it's not, as long as there's overlap, as long as the body parts are the same. But unfortunately, Pasquotto found that a CNR, quote unquote, without more is not an award, and there is no case that says it is. We've been putting our rating strings in the CNR ever since 2006, hoping that we'll get a case that says that that's sufficient to constitute an award for purposes of Labor Code Section 4664. It's never happened, but we're still doing it and we're still hopeful. All right, again, why not try? Help out the next person. What about a denied claim? We could still use Thomas language, like if we were settling voc rehab. That is not effective against the other side. I'm kind of running out of time, so I'm going to skip this example. But we don't have a Thomas, but we use it against lien claimants. That's the short answer. Once we've put Thomas language in and we've established that the injured worker might not have a case, that there's an issue that might defeat their claim, that sort of shifts the burden to lien claimants and we start having the upper hand, so we still use it. What if they're not PNS? What if they're not an MMI? Can you settle? Of course, you just have to use language that justifies it. Estimate the level of PD. Again, that can be difficult, but in cases where you have very common injuries that you see a lot, we talked about this, an experienced practitioner can value these things and provide an estimate of permanent disability, and that's helpful to the judge. Thomas type language, if you're settling for nuisance value, or even higher, if there's an issue that would defeat the claim, but the stakes are so high that you're willing to throw 100,000 at it, that might make perfect sense. Just explain it. This is language that you're going to want to keep. I use this in every case in which the applicant is not MMI. I add in the comment section, applicant does not wish to participate in further discovery, either deposition or medical legal evaluation. That doesn't give the judge very many places to go. If the applicant doesn't want to participate, you could, in theory, if they miss a QME, get their right to benefits barred ultimately. So that is very helpful in establishing that it's adequate, even though they're not MMI. Additional attachments, when to use an addendum. Again, don't use the boilerplate addenda that have all kinds of hold harmless for the defendants and settling all kinds of claims that are not before the board, but provide an explanation. We talked about it, for example, for TD, if it was paid in different periods, provide the periods. Whatever will help the board see what has happened. This is red flag language that we talked about, the known or unknown injuries, settlement of civil or FEHA claims. We used to write, this settles all injuries to body parts mentioned in the medical record. That's too broad now, so I just won't allow it. Now, if you have a structure, provide in the payment section or in the comments that your payment is going to be made in accordance with the terms of the structure, and then put that structured quote in as an attachment so they know how things are supposed to be paid. MSA, I would list, particularly if you're structuring the MSA, put that in the deduction, because that check is going to an annuity company, not to the applicant. So that's a situation in which you absolutely want to explain that that separate check that is funding the MSA is going to the annuity company. The seed money goes to the applicant, they put it in their MSA account, but the annuity for the future payments goes to the annuity company. Think if you actually need anything more than just standard language. And under the threshold settlement, you just want to say this protects Medicare's interests. If you're settling without an MSA, you just represent that they're not eligible if you don't think it's needed. If you're under the review threshold, again, Medicare's interests are protected. Make sure you get the settlement with either 2 witnesses or a notary. For a while there during the pandemic, we didn't need that. Now we're back, we need it again. These are the signature sections. There is, This is for the witnesses. This is for the applicants and defendants. This is for a notary if they need one. Upon approval, this is important. If you don't mention something in terms of deferring the issue, it's deemed resolved, and any penalty that applicant would claim related to that issue, whatever you're settling in that CNR, goes away unless it's mentioned in the CNR. So that's helpful. Potential claim is gone. I'm running out of time, but there's a number of things that you need to submit, particularly if you have a pro per. Here, they're all listed in the PowerPoint. It's basically all the notices, all the medicals, how you calculated your earnings if they're not max, any DEU ratings. I would just provide documents that you feel are needed to support your settlement, particularly if there's an attorney on the other side. Executed and signed settlements, supporting meds, proof of service, and again, supporting documents for earnings. And a cover letter explaining your settlement goes a long way too. Now, if you get an order suspending action, don't panic, read it. Typically, the judge is asking questions. Just answer the questions or provide the requested documents, and typically you'll get an approval. I think we're out of time. Here's my contact information. Feel free to get a hold of me if you have any questions. Thanks. I'm going to toss it back over to Tammy.
Thank you so much, Greg. That was a fascinating information. I hope you all thoroughly enjoyed it. Greg mentioned the PowerPoint. There is a link in the details at the bottom of this video. So thank you again for watching. Be sure to request your certificate by clicking the training certificate request link in the details at the bottom of this video under more. And again, you're also going to find a link to the PowerPoint under more as well. We offer monthly live webinars, which you can register for on our website at bradfordbarthel.com under the training tab. You will also find complete instructions for requesting your certificate on our training page if you are having trouble with the link in this YouTube video. Thank you so much again, and I hope you all have a great day.